Okay, well, good afternoon and welcome to the second annual web-based Academic Vision for Excellence seminars, also known as WAVES, which is hosted by the Wyoming Department of Education Special Education Programs Division. I am Dina Smith with the Wyoming Department of Education, and I'll be your host today. Today is the first of a two-part series for special education law with a focus on least restrictive environment, or LRE. The next session in the series will be held April 14th from 3:30 to 5:30, and it will be a focus on a response to lack of progress. We are also blessed to have Margie Robertson, our State Special Education Director, with us today to share some welcoming remarks about this important topic, least restrictive environment. Following Ms. Robertson's remarks, I will go over some important housekeeping announcements for this session. It is now my honor to turn the time over to Ms. Robertson.
Good afternoon, everybody. Thank you so much for joining us. And thank you, Dina and Tom and special education staff for putting this together. And in just a moment, our special guest. This is going to be so important and meaningful. I would just like to say that LRE is a critical component of IDEA. And to really understand its importance, I think we need to put ourselves in the shoes of parents of children prior to IDEA, who were told that their children didn't get an education, that their children could not come to school. And those children oftentimes were kept at home or in nursing homes or in facilities. And then we had the wisdom, because parents fought so hard for their children, to offer an education. But oftentimes, initially, that education was in a separate school or a separate room, and those children did not get to interact with typical peers, which is not how our society is. And so it wasn't a best practice. And thank goodness today, under IDEA, children with disabilities have a right to receive a free and appropriate public education in the least restrictive environment. That is to say, educated to the maximum extent appropriate with non-disabled peers. So I start with that really to say that it's the right thing to do to educate children with typical peers to the greatest extent appropriate for that child. It is also an evidence-based practice. I can't tell you how many stories I've heard this year from parents of children who weren't being able to walk or talk or have appropriate behaviors. And by being in a typical environment with typical peers, children their age, they were inspired to begin walking. And those children now are being able to take steps and are much closer. They've closed the gap with typical peers simply from the learning that happened from their typical peers. So I just want to talk about how important it is, that it is a best practice. It is an evidence-based practice, and it's also a right, which we're going to spend a lot of time talking about today. And one of the pieces that I wanted to share is that, today we don't start with a child being in a special education room and look for opportunities to push them out. That's not what the law says. We start with looking at how can we educate them in a general education environment with typical peers and provide all the supports necessary in order for them to be successful. And when we have data, sufficient data to say that that is not the best educational setting for that student, then we move down the continuum into another setting or another placement, depending on, and there's a lot of movement in between. Like, we don't just jump to a different placement, right? We provide those levels of support along the continuum. So we're going to learn so much today. I'm very excited because this is important pieces. I want to say it is a right, and so much so that if a parent or any individual, honestly, in our state files a state complaint, we are obligated to investigate it. And if a child is not being educated in an environment with typical peers at no cost to the parent, it can result in corrective action and findings against the district. And so it really is important that everyone understands the process and the rights of the child. Today, I know we've provided a copy of a state complaint corrective action, a report for a state complaint. All of the private information has been redacted. but it has some really great language to explain what happens and what has to be investigated should a parent make a complaint. So that also will be referenced throughout today. And we just hope that we will answer all your questions and give you an opportunity to really sharpen your processes because we want to improve outcomes for students. And again, we just thank you what you guys do for our students with disabilities. And again, thank you for being here today, Dina.
Thank you so much, Margie. For time considerations, I'm going to go ahead and introduce both presenters, and then I will turn the time over to Miss Amy Goetz, who will present first today. Miss Amy J. Goetz is a private attorney and founder of the School Law Center, an education law firm representing students and families in Minnesota, Wisconsin. Her practice includes work on cases involving special education, student discipline, discrimination, including harassment, bullying, juvenile court referrals from schools, general education, athletics eligibility and participation, restraint, and seclusion. Ms. Goetz has successfully resolved hundreds of student and family claims through formal and informal means, obtaining favorable results that have significantly impacted the lives of children and their families, as well as changing and improving school and legal systems. She is a mediator for a number of state education agencies and due process hearing officer in Utah. She is a trainer and teacher, having presented numerous seminars on various education law topics to parents, attorneys, judges, and other groups, as well as regular lectures in education and law classes in the Twin Cities area. She has worked in education law since 1995, first as a staff attorney with the Minnesota Disability Law Center in Minneapolis, then as a complaint investigator at the Minnesota Department of Education, and finally as a student and family lawyer in a private law practice. Ms. Goetz is admitted to the Minnesota and Wisconsin state courts, the Minnesota Federal Court, the 8th Circuit Court of Appeals, and the United States Supreme Court. And I just want to tell her congratulations because she's also just recently received a national award from COPA. So congratulations, Amy, on that. And she is also the proud parent of 2 beautiful adult children with disabilities. And our other presenter, Jose Martin, JD, Jose is an attorney at law. He is a partner with the school law firm of Richards, Lindsay, and Martin LLP in Austin, Texas. His practice focuses exclusively on disabilities, issues, and litigation affecting public schools, including special education, consulting, and litigation under the Individuals with Disabilities Education Act, or IDEA. Also with Section 504 of the Rehabilitation Act of 1973 and the Americans with Disabilities Act. Mr. Martin graduated from the University of Texas and the University of Texas School of Law. And in April, he will have been a practicing attorney for 30 years, all in special education. He has presented in more than 40 states, from Hawaii to Florida to Alaska to New Jersey. He's also been partnering with us here in Wyoming at the Department of Education to bring quality professional development and guidance on special education issues since 2007. And we are so grateful, Jose, for your partnership with us. It is now my distinct honor to turn the time over to Miss Amy Goetz.
Thank you. Good afternoon. Thank you to Dina and all the other folks at the Department of Education in Wyoming for giving me this opportunity to present today on this important topic. And thank you for the opportunity to present with my old friend, Jose Martin. We've been together on a number of presentations, and it's always a pleasure to work with you, Jose. So my presentation is going to focus today on virtual settings and parent choices. And so I wanted to start with this slide because it shows you some of our youngest learners working in virtual learning, in distance learning many years ago. And this doll just happens to be my granddaughter, Ruby, who was precocious. And I don't know if she was really typing there, but she was practicing what her mom does, which is a lot of work on a computer. So there she is. Hi, Ruby. So let's see. There we go. So least restrictive environment. It's one of what I call the twin pillars of the IDEA. You know, we have free, appropriate public education, and then we have least restrictive environment. It also is a tenet, and an important one, of Section 504. And oftentimes in schools and in serving students with disabilities and in talking with parents and in looking at the law as it has developed, and I've practiced almost 30 years as well, watching 504 and its development has been a snail's pace, really. And 504 and the ADA have been in many ways eclipsed by special education. And they are coming out from under those shadows. So Section 504 also includes those twin pillars, a right to a free, appropriate public education, and to have that be in a least restrictive environment. So both of those laws support one another. Both of those laws protect any student eligible under either or both of the protections of the Individuals with Disabilities Education Act or Section 504. I really appreciate the opening remarks by your director that this is the right thing to do, because it is. Compliance aside, litigation aside, disputes aside, the first and foremost reason to be concerned about least restrictive environment is because it's the right thing to do, because we've decided as a society that children with disabilities have the right to be educated alongside their non-disabled peers, and that's good for everybody. It's good for those students, it's good for their peers, it's good for their families, it's good for our societies. It helps everybody recognize that we live in an inclusive society and that we want all children to grow up recognizing that and appreciating that. And there are significant scientifically based findings and data on which the least restrictive environment mandate was first decided and enacted, and through which it's been strengthened over the years. There are materials included in the handout section. There's a joint policy statement by the Department of Health and Human Services and Department of Education that contain a variety of references to those research based conclusions about why least restrictive environment is good for all of us. So I urge you to go to look at some of those resources. So to the maximum extent appropriate to their needs, children are entitled to be educated in typical environments, regular classes, and often that requires the use of supplementary aids and services. And so the law starts with the presumption that students with disabilities will be fully included in the general ed classroom with typical peers and supported as necessary with effective, which means based on peer-reviewed research to the extent practicable, supplementary aids and services. First consideration always must be given to placement in a regular classroom with necessary supplemental aids and services before considering any restrictive placement. The Office for Special Education Programs has consistently sent guidance to the field to that effect. And it is cited in my handout that is also included in the materials available to you. Students can't be excluded from the general ed classroom based on a need for a modified curriculum or one-to-one assistance or any other supplementary aid or service that can be brought into the general ed classroom to make that child successful there. The balance always has to be struck on a case-by-case basis, never based on categorical decisions like the configuration of the service delivery system or the availability of educational or related services or the availability of space or administrative convenience. Again, that language comes from a letter to the field, letter to Van Wart, cited in the materials from the Office for Special Ed Programs. So we expect effective supplementary aids and services are provided, and we presume the full inclusion of all students. LRE is balanced by FAPE. So they are the twin pillars. They are in balance with one another. Both of the rights to FAPE and LRE exist in the IDEA and Section 504. The paramount right, however, is the right to a free, appropriate public education. That is, when these two considerations are balanced against one another, if a child is not receiving a free, appropriate public education, and there are not supplementary aids and services that can be brought into the regular education environment to make that successful for the student, then FAPE gives way. Then LRE gives way, because FAPE is really the paramount consideration. And to the extent that a child cannot receive a free, appropriate public education in a general education classroom, then bit by bit, we have to look at removing them from the general education environment in order to, and only to the extent necessary, to provide them a free, appropriate public education. Those decisions, as all other important decisions in special education, of course, are made by the IEP team, who has to consider, has to discuss, has to decide whether the student will receive academic and non-academic benefits in the general education classroom. There's a continuum of alternative placements in this law. Regular classes, special schools, home instruction, instruction in hospitals and institutions. Placement decisions are always made by teams, the people who know the child, know the evaluation data, familiar with placement options, who know and understand and can fulfill the legal obligations to engage in the discussions that are necessary to make these important decisions. In making the least restrictive environment choice, the IEP team must consider any potential harmful effects on the child or on the quality of services that are needed. Again, and I think this is really such an important point, I'm going to make it again. Children may not be removed from age-appropriate regular classroom environments solely because they need modifications to the general education curriculum. LRE is everywhere. It's in extracurriculars, it's in non-academic activities, it's at lunch, it's at recess, it's in counseling and athletics, transportation and clubs. That is, children with disabilities are entitled to and benefit from, as do their peers, inclusion in all of these activities. Non-academic settings, extracurricular activities. The law is clear to the maximum extent appropriate, again, to the needs of the child with a disability. The district has to ensure, including by providing supplementary aids and services determined appropriate by the team, that the student participates with non-disabled children in all of these activities. Least restrictive environment, it's also everything. It's all encompassing. It includes not just access to peers to learn alongside peers without disabilities. It includes access to curriculum. It's been eminently clear in the Congressional Findings that emphasize access and LRE, that implementation of the IDEA can be more effective by coordinating special education with other school improvement efforts so that special education can become a service for such children rather than a place where such children are sent. These are the congressional findings to the IDEA. Implementation of the IDEA can be made more effective by providing appropriate special education related services, aids and supports in the regular classroom, can be more effective by having high expectations and ensuring access to the general education curriculum in the regular classroom to the maximum extent possible in order to meet developmental goals, meet the challenging expectations established for all children, and to be prepared to lead productive and independent adult lives. The IDEA also has a variety of content provisions. In addition to the explicit LRE provisions and the congressional findings. For many years, the focus of LRE has been the physical access to the mainstream classroom, but Congress and the Department of Education have made it increasingly clear that students with disabilities are entitled also to curricular access, to general education content and curriculum, and state standards that are applicable to all children. So the section of the IDEA that contains provisions that govern IEPs is clear that students with disabilities are entitled to access regular education from a content or curricular sense as well. In order to make FAPE available, the IEP has to be designed to enable the child to be involved in and make progress in the general ed curriculum, defined as the same curriculum as for non-disabled children. The very definition of special education tells us that it is the objective of special education to adapt content, methodology, delivery of instruction to address each child's unique needs and ensure access to the general curriculum so the child can meet the educational standards within the jurisdiction of the public agency that apply to all children. The IEP must include a statement of present levels of performance, including how disability affects his or her involvement and progress in the general curriculum. Has to include a statement of services for the child, a statement of the program modifications or supports for personnel to be provided so the child can advance appropriately toward attaining annual goals, to be involved in and progress in the general ed curriculum and participate in extracurricular and non-academic activities. Must include an explanation of the extent to which the child will not participate with non-disabled children in regular classes. There are essential components to education that Congress has been concerned with based on our society's concerns about education and inclusion of people with disabilities in our communities, starting with our schools. So other of the congressional findings emphasize these important concepts. One of the findings, two of the findings say the following: improving educational results for children with disabilities is an essential element of our national policy of ensuring equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. And before the IDEA, children with disabilities, of course, were excluded from the public schools and from being educated with their peers. Daniel RR is the case that originally came out of the Fifth Circuit Court of Appeals, recognizing the LRE mandate as one very specific directive prescribing the educational environment for students with disabilities, creating a strong preference in favor of mainstreaming. And it created this two-part test. Has education in the regular classroom with the use of supplemental aids and services, can that be achieved satisfactorily? That's the first question. And secondly, have we mainstreamed the child to the maximum extent appropriate, and again, appropriate to their needs? I think that Jose is going to cover some more of the Daniel RR considerations and factors that the courts look at in determining what is and is not the least restrictive environment for any particular child. Academic achievement's not the only purpose of mainstreaming. That's a pretty important part of the Daniel RR court decision. The 10th Circuit Court of Appeals, which is your Circuit Court of Appeals, adopted the Daniel RR standard for evaluating when a particular setting is or is not the least restrictive environment for a particular child. In this case, LB versus Nebo School District. And said this: educating children in the least restrictive environment is one of the IDEA's most important substantive requirements. That case involved a preschool child, and the court there rejected the argument that the mainstream placement for that student created too much reliance on the aid. The child was succeeding in the mainstream placement with an aid and intensive ABA programming, was the most academically advanced child in the class, and they were compelled by these facts. As at the more restrictive placement, she would be placed with students who functioned considerably lower. Her primary needs involved improving her social skills, and the mainstream program provided appropriate role models, had a more balanced gender ratio, and was generally better suited to meet her behavioral and social needs. Despite tantrums, they said she was not disruptive in the regular classroom. So I guess she had the non-disruptive tantrums. There are a variety of factors for the IEP team or 504 team to consider. They are highlighted in my handouts. Please refer to that. And they summarize the statutory law as well as the case law in terms of a guide for what IEP teams and 504 teams should consider. Section 504 is a train that's coming down the track. That's why I picked this picture, because again, it's been eclipsed by IDEA and it's been in the shadows for many years, and people don't really understand because it has not been well developed frankly, in litigation, and then in practice, it has not been a well-developed source of protection for children with disabilities. Certainly not the source I think that Congress intended. It like IDEA, ensures a free, appropriate public education, ensures a least restrictive environment, but it also goes further, frankly, than IDEA. It's a very important source of students' rights to equal access, equal treatment, equal benefit, and equal participation. Unlike IDEA, Section 504 requires a reevaluation before any significant change in placement. It's one of the, I think, least utilized, but really quite important aspects of Section 504 protection. Virtual learning. IDEA and Section 504 apply to online programs, to home instruction, to temporary homebound placements, to parent choice placements, except for private school placements, to COVID distance learning. So the Federal Department of Education, the Office of Special Education Programs, has provided, as I'm sure you all know, a lot of guidance about what to do during COVID shutdowns, when schools shut down, computers opened up, students went to distance learning, and the Department of Education has been clear that special education or related services provided virtually in the child's home has generally been considered one of the most restrictive environments. Typically provides little or no opportunity for the child to be educated with non-disabled peers. However, they go on to say in their return to school roadmap issued in 2021 that virtual learning provided during the pandemic may be deemed less restrictive if it's available to all children and provides the child with a disability meaningful opportunities to be educated and interact with non-disabled peers in the regular education environment. That citation is in my materials. Wyoming state law governs the provision of virtual education program content, agreements between districts and remote education, but it contains nothing specific to special education, although it does require the school district to monitor student progress, grade level assessments, and to facilitate necessary instructional support for the student and notify and assist any student not performing satisfactorily. So again, the requirements of IDEA and 504 apply to students with disabilities who learn through virtual or online programs, whether they're placed by an IEP team, whether they're receiving homebound services on a temporary basis, or whether they're enrolled in an online course of instruction. And that guidance comes from the OSER's Office of Special Education and Rehabilitative Services, questions and answers on providing services during the COVID outbreak. So these provisions under IDE and 504, they say, apply to the same extent that they apply to students attending traditional schools. Child find, FAPE, and LRE rights extend with equal force to virtual schools. COVID-related virtual learning. Students with disabilities continued to be entitled to a free appropriate public education in the least restrictive environment to the maximum extent possible, and the rights and obligations of the IDEA and Section 504 were not waived or reduced or suspended. When students with disabilities were provided the same access to learning with their peers without disabilities, they continued to be educated in the least restrictive environment. If students with disabilities were provided less or different services, less or different access to learning with their peers without disabilities, then least restrictive environment concerns may have arisen. The provision of virtual or online education or distance learning is consistent with IDEA and 504 during emergency school closures. And that comes from a supplemental fact sheet issued by OSERS and OCR. They were very concerned with providing flexibility, the Federal Department of Education, these departments, providing flexibility to schools during this unprecedented crisis. Quote, no one wants to have learning coming to a halt across America due to the COVID-19 outbreak, and the US Department of Education does not want to stand in the way of good faith efforts to educate students online, end quote. Each IEP team must ensure that when schools are closed, each student's right to a FAPE in the LRE is preserved in each operational model, including distance learning or hybrid learning, as provided by their IEP. Generally, when students with disabilities participate in online learning in a course with students without disabilities, that learning time can be considered regular classroom time. Here's a quote from a case out of New Mexico, the District of New Mexico, called Hernandez versus Grisham. Quote, providing children with disabilities with online instruction that's the same as the remote instruction that their peers without disabilities received is not a removal of children with disabilities from the regular education environment, because children with disabilities receive access to the same virtual instruction and materials as their peers without disabilities, end quote. That court went on to say that when most students are required to use remote learning, there's a rebuttable presumption that students with disabilities should likewise receive remote instruction. Now, the distance learning model used during the COVID-19 shutdown is neither home instruction nor a homebound placement, because it resulted from widespread school closures that affected all students, rather than a placement decision based on the educational or medical needs of students with disabilities. To many parents, it also required them to assume a significantly increased burden to educate their children with disabilities at home, often with unacceptable outcomes. Whether due to school closings or the needs of learners, online placements must always be made by IEP teams based on the student's individual needs. Don't automatically change the least restrictive environment balance because of school closures. Available technologies can make a student's regular education environment accessible to the student with, for instance, live audio streams, audio video streams, storage devices in order to maintain the LRE for a student who's unable to attend school in person. IEP teams should consider available technological modifications to access direct instruction for students unable to access in-person instruction. Robot avatars that transmit audio and video and move about the school under the control of the homebound student present promising links to the regular education environment, experiences, peers, and curriculum for virtual access to school, creating virtual attendance and socialization opportunities. Parent choice online placements. So IEP teams can place children into online programs. They have to consider LRE. They have to consider FAPE. Parents can choose to place children in online programs. It appears many virtual instructional programs are meant to be and available based on parent choice. But if that program receives federal financial assistance or is a public school, then the IDEA and Section 504 requirements will apply, including LRE. Compliance issues are going to arise with virtual programs that would categorically deny admission to students with disabilities or create admission criteria that tend to exclude students with disabilities. If virtual instruction is available to all students in a local education agency, then the agency has to ensure the child with a disability whose needs can be met through virtual learning, that they have an IEP implemented that provides all the services and supports necessary for the child to receive FAPE through such delivery. That guidance comes from that return to school roadmap issued by OSERS. The traditional LRE analysis assumes education will generally take place in a school building with the opportunity for students to be educated alongside their peers without disabilities. There certainly are going to be disputes about whether virtual programs afford education with students without disabilities, about the quality and quantity of inclusion in online education programs. Questions will arise about about whether students with disabilities can be encumbered in access to virtual instruction by additional processes required for their admission, whether parent choice affects the student's right to education in the least restrictive environment or the right to a FAPE. Questions arise about whether it's fair to anyone to expect every school choice option, charter schools, virtual schools, that they have or can build the capacity to effectively serve all learners. Does online learning with peers without disabilities provide the same academic and social benefits embedded in the LRE preference for students in a school building? The answer, of course, can vary depending on the particular needs of the student and the particular features of the online program. What about expecting increased responsibilities of parents to facilitate online learning? Lots of questions. Homebound instruction. I've got just a few minutes here. I want to be respectful of my time. The IDEA uses the term home instruction to describe a placement on the continuum of alternative placements. It's always considered extremely restrictive because it restricts learning with peers without disabilities, not to be confused with homebound instruction, the temporary type of placement for students with temporary medical conditions. A placement at home for instruction of an IDEA or Section 504 eligible student is made by the IEP team or the Section 504 team based on the child's individual needs. It also is not to be confused with homeschool, which is a unilateral parent placement at home and considered a private school placement. So these are the parent choices: home-based or homeschool, charter school, extended virtual instruction. Wyoming has a homebound services law that does not seem to apply to children entitled to receive a FAPE. And so it appears as though Wyoming's homebound services law intends to defer to IEP team or 504 team decision-making on homebound instruction for these learners. Again, homebound placements are the most restrictive. Homeschool placements are governed by Wyoming statutes that define exceptions to compulsory attendance. Parents have the right to homeschool their children, and a home-based educational program is defined again by state law, and it defines private school as including home-based instructional program. Consequently, homeschool students are only entitled to a proportional share of school district funds to provide special education like other voluntarily enrolled private school students. They're entitled only to equitable services, not the product of IEP team decision-making, not required to be based on a student's individual needs, but based on school district determinations in consultation with private providers of the proportional share services. So students in homeschool are private school students. They're not entitled to a FAPE, and they don't need to be in the LRE. Charter schools, IDEA and Section 504 apply. And when public schools place students with disabilities in private schools, of course, 504 and IDEA apply, all of the features, but those features do not apply to parent placements in private schools. Thank you.
Amy, thank you so very much. That was very rich in content, and I'm really grateful for all of your handouts that you gave so that we can go back and reference those throughout and later after this presentation. So I appreciate that. At this time, I'm going to turn the time over to Jose to give any remarks just about Amy's presentation, anything that came up from her presentation, so that Jose, I'll turn that time over to you.
Not in the sense of reaction or disagreement, but just kind of some clarifications or thoughts that arose from this. I have Amy sees a construct of the law being based on these two pillars, which are FAPE and LRE, and I just have a different mind construct about them. You know, I see legal topics a lot in terms of pictures and math equations. And in this situation, I see a picture, and to me, it's a house. And it's a house that, for whatever reason, is on the shoreline. It's oceanfront, so it has these pillars that lift it. And I see the house as having 4 pillars. And the house, to me, is FAPE, because that's what it's all about. It's providing an appropriate education to students with disabilities. And I see this house built upon 4 pillars. One of those pillars is the concept of annual planning for students' education through IEPs. And that construct, which has been with us since the start of the law, that we're going to plan year by year a child's education. The other pillar is evaluation, that we're going to make decisions based on data, that we're going to evaluate students and make our decisions based on that evaluation. I see that as another pillar. And the third pillar I see is parent participation in the process and the safeguards that ensure this parental participation. And the last pillar is LRE, that we want FAPE to be accomplished in the least restrictive environment. I agree with Amy when she says in the balancing, you know, FAPE is first, FAPE is primary. Of course, you want FAPE in the least restrictive environment, of course, and that's where the balancing comes in. Just a different mental construct to me, that house, which is the key idea of FAPE, being built on these 4 pillar concepts. I also agree with her in terms of the origins of the LRE requirement. I think part of them are moral, ethical. Is it appropriate to separate students? Is a separate environment inherently a different environment, and is there a sacrifice in that? And I think that's part of it. And also, I also agree that there's just certain benefits from students with disabilities learning alongside students without disabilities. The modeling opportunities that can happen in terms of modeling of social behaviors, of age-appropriate behavior, age-appropriate verbal skills and academic skills. Kids learn a lot from each other, and that's part of the process. If you're interested in this topic, look at the work of Dr. Lou Brown, and he talked also about the intangibles of growing up in an environment as a student with a disability, with persons and kids without disabilities, because that kid that you grow up with may be the future bank president or the future restaurant owner who will hire you. But if he doesn't know you because you weren't around, then maybe that opportunity is lost on you. So it's part of that networking is at first. Her comments took me back to my public schooling in South Texas. And as I think of it in terms of the late 70s, when IDEA would be in effect, I was in high school. And in South Texas, I had this concept that I knew there were special ed students. I just never got near one, because they were in separate environments. I think I would see them walking to their usually inferior portable facilities, but I never had the opportunity to be near one. And I think modern kids, as a result, I think are much more exposed to students with disabilities and just don't think it's a big deal to have students with disabilities in their regular classes. It's just how they've grown up. They want to make a comment. Which is the most restrictive environment possible under IDEA? Amy said it's homebound. It's true. A homebound environment is highly restrictive in that you don't have opportunities to learn alongside non-disabled students. Heck, you don't have opportunities to learn alongside disabled students, right? Because there's nobody at home but you. You're the only one. So that's actually a pretty restrictive environment. But I think close is residential placement, right? Because residential placement, you're not even sleeping in your own bed. You're in some facility, perhaps in another state. There may be peers, usually with disabilities, okay? But you're not even in the home, you're not even in the community. So those are close in terms of the most restrictiveness. And I also wanted to comment on just one aspect of the virtual programs and the role of students with disabilities in virtual programs. Even before COVID, there was an increase in proliferation of virtual programs out there. And there was an increase in the participation of students with disabilities in these virtual programs. And the questions that Amy's talking about, where does a virtual environment fit in terms of LRE, particularly when we have a law that never envisioned virtual environments, only envisioned brick and mortar schooling. So it's not really outside of the legal framework. Where does that fit in? And can these programs be expected to serve all kinds of special education learners? I think I can answer that last one, and the answer is no. The virtual or online education environment cannot be expected to meet the needs of all kinds of special education students. Why? Because no program can do it. The regular classroom, a resource classroom, there's no program out there that is designed that it can meet the needs of all kinds of learners. Now, the virtual environment is not going to mesh and match with the needs of certain students with disabilities, and we have to live with that. And I think that the COVID experience has taught us that.
Thank you very much, Jose. Jose, thank you for this wonderful presentation. I'm excited to hear all that you've got prepared for us today as well. So I will turn it over to you.
Great. Thank you, everybody. And I really liked Amy's remarks. I want to add to them and address some different topics in LRE. And let me see, how can I move the page? Here we go. Okay, so what is LRE? You know, actually, I think it's rather a confusing question, because I think that when I've done sort of a law school type of presentation on this where we raise the question and we kind of approach an answer by hearing different answers to the question and seeing what's flawed in them. You always get this answer, what's the least restrictive environment? And I always get the answer that it's the general education classroom. I tend to follow that up by indicating, so every student that is in a homebound program, we're violating the law, right? And then people will say, well, that doesn't sound right because there's a lot of students on homebound. Can we be violating the law with all of them? Are you violating the law when there's a student that's been placed by an IEP team in a residential program? So the idea is that it's a fluid concept. It's what's the least restrictive environment for a particular student is going to be different than what the least restrictive environment is for the next student. The least restrictive environment possible is full-time regular education classroom, but that might not be what the least restrictive environment represents for a particular student. So rather, I think the answer is more of a concept or an analysis, a formulation that we can articulate. And I've tried it here in two ways, which I think both are appropriate. One is that LRE, or the least restrictive environment, is the educational setting within which the child can receive a FAPE and have maximum appropriate exposure to non-disabled students, okay? The balancing that Amy talked about. We want FAPE, but we also want to have maximum exposure to non-disabled students. In a sense, I sometimes think that LRE imposes a sacrifice, right? Where would students get probably maximum progress? Likely in segregated programs, because that's where the highly specialized teachers are, best staff to student ratio and lower number of students. But we're willing to sacrifice maximum benefit to accomplish appropriate education, meaning, appropriate progress in light of the child's circumstances in less restrictive environments and environments where you have maximum exposure to non-disabled students, because we know of the benefits to that. Another formulation, if you can wrap your head well around the first, is it's the educational setting within which a child's IEP can be implemented properly that allows for maximum exposure to non-disabled peers, okay? By the way, none of us tend to talk about the fact that this is a really clunky phrase, least restrictive environment. It's not one of those phrases that are kind of self-defining. Is it about a level of restriction on the child, a bodily restriction? No, not at all. Actually, if I had been asked what this concept is about, I probably would have called it the SE, the least segregated environment, because what we're striving for is the least segregation possible from non-disabled students. But they didn't ask me back then. Well, yeah, I guess maybe because I was in middle school. Here's a foundation of LRE. LRE is a big requirement, as is indicated by the previous slide. So to digest it properly, we operationalize it, some say weaponize it, by having certain regulations that help us understand and implement this requirement. So here I'm going straight to the concept of the regulations. And I cite each regulation here. It's a federal regulation because of that CFR thing. That stands for Code of Federal Regulations. And if it starts with 300 point something, it's an IDEA reg. Okay, so we start with the first one. There's an IDEA reg that just spouts the LRE requirement. We have to educate students with disabilities with non-disabled students to the maximum extent appropriate. And now we get into some concepts that flow from that original concept, okay? We can only move a child from a less restrictive setting to a more restrictive setting if we properly determine that a free and appropriate public education isn't possible in the less restrictive setting, even with legitimate efforts at providing supplementary aid services and modifications. But we don't even think about moving the child out, for example, of the regular class until we make a determination that despite our legitimate efforts at providing supplementary aids and services, special education services, accommodations, modifications, assistive technology, everything you can throw at it in the kitchen sink also, that the student can't receive a FAPE there. Then you start moving, then you start thinking of more restrictive settings. That's kind of the way that it works. I'm gonna give you a fancy graphic in a second, an attorney-made graphic that'll show you this in a picture. And part of the LRE requirement is there's a sub-concept that flows from it, and that is the continuum of placements. Also kind of clunky. It's always sounded to me a little Star Trek-y. Continuum, right? The continuum. The idea here is that there's a mix, there's a variety. We have a variegated system of settings, and the school districts must maintain a variety of types of settings for students with disabilities. And then part of this is itinerant special ed instruction that's provided in regular classes. You know, I mean, we used to think of special ed as a place you go to, but why can't special ed come to us? Why not? Okay, thus we have inclusive educational programming where special education services and instruction are brought in and committed within the concept of the regular classroom. And it's happening within the concept of the regular classroom. So you don't have any danger of an unnecessary modification to the curriculum. The child's accessing potentially the full curriculum, and special ed instruction is being brought to bear so that the student can access it. This is the idea of continuum of placements, that you have at one part, you have the general education classroom, the least restrictive environment possible. At the end of the spectrum, you have homebound, according to Amy. I think homebound or residential placement, they're kind of a tie there in terms of restrictiveness. Now, this regulation, which is an important one, 300.116, by the way, these regulations and the core concepts therein are embodied in your special education rules and regulations at the state of Wyoming. If you look at Chapter 7, I found the LRE requirements at Section 5B, and they're basically, it's a rephrasing and a restatement of the requirements of federal law, which is perfectly appropriate. That's kind of what you have to be. And part of this is, well, how do we make the LRE decision? And the how is answered in this slide. IEP teams have to make placement decisions for IDEA students, and they have to do so at least annually. And, you know, when you make a placement decision, that's where LRE rears its head, because is this the least restrictive environment? That's a placement concept, right? So the idea here is that it is the IEP teams, which of course contain and include the parents, that make the placement decision. And as with the IEP, this placement decision has to be made at least annually. In most states, this happens through the annual IEP team meeting process. This next regulation is really important, particularly for those that have trouble understanding why there's a sequence of decision-making in the IEP team process. And this one answers why placement comes at the end. And that's because placement decisions made by the IEP team must be based on the IEP. So you don't know where the child should be placed until you decide what's the appropriate IEP for the child. Okay, what are the goals of the program, and what services are you going to bring to bear, and how are you going to measure their progress? Once you make a decision on what the IEP contains, at the end of the process is, well, where's the least restrictive environment where we can do this monster? Where can we do this IEP? Thus, you have the decision-making sequence, as I set forth in the IEP process. The last part of it is, where do we put the child? What's the least restrictive environment? The environment where the student will have maximum exposure to non-disabled students, but where we can also implement this IEP, assuming, of course, you have an appropriate IEP, it's appropriately implemented, it gives you a FAPE. Then we're told, now here's part of LRE, as we see in the operational structure of the regulations, is the campus. Campus decisions are a part of LRE. What school the child goes to. And here, the Congress and the Department of Education basically established sort of a default placement or a preference placement. And the idea here is, unless the IEP requires some other arrangement, we want the child with disabilities to be placed in the school they would attend if they were non-disabled. Okay, wherever they would attend, if they happen to be a non-disabled student, is the school where we would like them to be placed and receive their special education services, unless the IEP requires some other arrangement. That's the default placement, the child's regular home campus. Now we're told, unless the IEP can't be implemented in the settings offered at the home campus, the law has made clear that every single little elementary doesn't have to have every piece of the continuum of placements. That would be a waste of resources. You'd have a lot of classrooms with one child, incredibly wasteful of resources, and actually contrary to LRE. So the idea is, if in your neighborhood school, you don't have the exact services or settings that you need to implement your IEP, then we move to another regulation. And this other regulation says, if you can't be in the home campus because the home campus doesn't have the capacity to implement your IEP, then you should be placed as close as possible to your home, the next closest campus that in fact does have. So if the home campus can implement the student's IEP, then we move to the next closest campus to the home that is capable of implementing the IEP, meaning the campus that has the appropriate setting, for example, that might be necessary to implement a child's IEP. That's another part of that important regulation 300.116 at the federal level. Then there's certain pros and cons of making placement decisions. For every placement decision we make, there's potential benefits and there's potential downsides. And this regulation, this subsection actually of 300.116 tells us that in making this placement decision, the IEP team has to consider the potential harmful effects on the child or the quality of the required services. We have to think of the cons when we're making a placement decision. What are the negatives of the placement decision? This requirement is embedded usually in your IEP forms, and it requires some discussion. And I must tell you that, and this is sort of misunderstood, this requirement for consideration of harmful effects applies whether you're considering a move to a more restrictive setting or you're considering a move to a least restrictive setting. It applies to all placement determinations. When the child's moving to a more restrictive setting or you're considering that, there's going to be some potential harmful effects. Moving to a more restrictive setting, you're going to minimize the child's social opportunities and modeling opportunities for non-disabled students, for example. You're going to lose some of those benefits that Amy talked about in terms of inclusive programming, but you're gaining some, right? Well, you're gaining some more condensed and more specialized instruction, potentially in a more structured setting, in a lower staff to student ratio setting with better trained teachers and so forth. And the idea here is that in making the placement decisions, the IEP team has to talk about the pros and cons. When we're moving to a less restrictive setting, it's not all roses. You move to a less restrictive setting, and what you can have is you can lose the opportunity to participate in more specialized programming and programming that's more custom tailored to you, for example. So that can be some of the harmful effects. There's going to be harmful effects in every placement decision. And the idea here is that the IEP team has to think about it and has to talk about it a little bit as part of the IEP team process. Whoops. At times when we talk about harmful effects, such as, I hear this one's pretty common. If we move the child to a more restrictive setting, well, there's going to be a stigma, there's going to be an impact on the child's self-esteem as a result of the move to a more restrictive setting. That is a harmful effect. That is something that can be present. But at times, the point I'm making is that a harmful effect can be addressed. Okay, so if you have potential stigma of needing special education services in more of a special education setting for part of the day, perhaps that can be addressed through some other services, for example, counseling, to help the student understand why this is a benefit for him and why it's necessary for their education. At other times, you have a harmful effect and there's just no getting around it. And it's simply the IEP team has to consider weighing the benefits of the placement versus its potential harmful side effects, because at times there's no minimizing or mitigating a harmful effect. It's present and it's just not going to go away. This last regulation, this last subsection actually added more recently. It didn't start at the inception, and I actually think it's superfluous. I think that this regulation would be true and its substance would have to be acknowledged even if it didn't exist. And that is that you can't remove a special ed student from a regular classroom just because they need classroom accommodations or modifications. Okay, obviously, I think that comes from the construct of the law. You want to start in the regular classroom, and you provide classroom modifications, accommodations, services, assistive technology, supplementary aids and services. And you can't say because the child needs those, that means that the child has to go to a more restrictive setting. No, absolutely not. That's not the way that LRE works. And this requirement, by the way, is already part of that Fifth Circuit LRE analysis that Amy talked about, that Daniel RR case. That case is near and dear to me because it comes from El Paso, Texas, a district where, a city I go to and where I represent clients. Here it is, by the way. And this is a slide on how courts analyze LRE cases. So, if we get to a tussle in terms of, the parent thinks this isn't the LRE and there's an LRE dispute, and how do the courts decide it? And there's kind of three schools of thought. The Ninth Circuit has sort of a version. It's their Rachel H. Other circuits have called a more Ronker formulation, where there's like a weighing of the pros and cons. And then there's a Daniel RR analysis, probably the oldest analysis. It comes from a case. It reached the Fifth Circuit in 1989. So obviously it originated probably in 87 or so in El Paso Independent School District. And this has become probably the most preeminent LRE analysis in the federal courts. This is getting pretty legal here. If you notice, that's the Fifth Circuit. Obviously, it's a Fifth Circuit case, so it applies in the Fifth Circuit, but it's also been adopted by the Third Circuit. It's been adopted by the 11th Circuit. And most importantly for you guys, it's been adopted by the 10th Circuit. Why most importantly for you? Because Wyoming is in the 10th Circuit. So if there ever was a scrape with LRE, that happens. And Amy got the case right. The Nebo Board of Education case of the 10th Circuit in 2004, which is your circuit, decided, you know what, we're going to jump on the Daniel RR bandwagon. Surprising to me that an LRE case had not previously reached the 10th Circuit in terms of deciding what kind of analysis to adopt until 2004. That's fairly recent. But in 2004, they said, and by the way, if you look at that case, if you look at that Nebo Board of Education case, it's pretty interesting because they look at the Rachel formulation, they look at the Ronker formulation, and they look at Daniel RR, and they say, we think Daniel RR is closer to the substance of the statute. And it is, as Amy told you, it is a two-part test. And the first question is, can the student receive a FAPE in regular classes with the appropriate supplementary aids and services? So if you notice that default placement in regular classes is embedded in the statute, but it's a big question. So there's some sub-questions to it. And the second part of the analysis is, okay, if the child can't be educated in regular classes, do you have them in regular classes at least as much as possible? Okay, we hear an understanding that it's a gradual, it's a mix, it's not an all or nothing type of proposition. But I want to get back to that first question because that's a big one. Can the student receive a FAPE in a regular education classroom? And the court said, that's a toughie. That question requires asking some sub-questions. In fact, 6. Okay, so the court said, we think to answer this question, schools and courts have to think through 6 factors. Okay, and they said the first one is, have you even tried? I like that one. You can't say regular class won't work if you haven't even tried it. Again, it's subsuming the idea of the default placement as being in regular classes, and that's the starting point. So crucial to the first question is, has the school attempted? Have you tried it? And I love the second question. Did you try with feeling? Did you really try? Were those efforts sufficient? And not just mere token. Did you just stick the child in a regular class with no support so that they would fail? And you could say, see, failure. The child has to go to a more restrictive setting. No. The court's assumption is you've got to try, and you've got to try with feeling to make it work in the regular classes. It can't just be token attempts at meeting the child's needs in regular classes. They have to be serious attempts. Then a question that has to do with staff and teachers. Okay, will most of the teacher's time be devoted to the one special education student or to modifying the curriculum for him or her? Because if most of the teacher's time is going to be absorbed by the student, then perhaps this isn't the LRE. You know, in most areas in special education, we don't think of the other kids, okay? And we don't think of cost. But actually, if you look at the LRE formulations, impact on other students is relevant. And cost is also, particularly if you look at the Rachel formulation out of the Ninth Circuit. So if most of the teacher's time is going to be devoted to the one child or to modifying for them, the idea is that then that's an indicator that this isn't the least restrictive environment. By the way, if you notice these 6, to me, I kind of go through these 6 and I mark them. Is it positive or negative? Is it positive for the child needs a more restrictive setting, or is it negative? And you kind of add them all up. Part of having a multi-factor analysis is can be difficult to apply. The late Supreme Court Justice Antonin Scalia, he hated multiple factor tests because he said that they bred inconsistency. But it's a complicated world. Sometimes you need multiple factors. Then another question is, can the student receive educational benefit in the regular classroom? Is FAPE really even feasible? Has the experience of the student in the educational setting of the regular classroom, even with supplementary aids and services, shown us that it can't happen because of the child's progress or lack thereof? And that's related to the next question, which is, what has the child's overall experience been in the regular classes? Do they cry all the time? Are they hiding under the desk? As I had in one LRE case, is the child bolting from the classroom every chance they get? Is if the child's overall experience in the regular classes is pretty negative, that tends to be an indicator that maybe they need a more restrictive setting. And the opposite is also true. If the child's overall experience in the classroom is positive and the child is happy, then that tends to indicate that the child isn't the right setting, that the child's regular classroom is the right setting. By the way, this reminds me of a case at the start of my career. And I remember that the hearing officer, this was unusual, required both of the attorneys to observe the child in the regular classroom setting as part of the preparation for LRE. And I observed the student and I reported back to the school board, and I thought, she participates, she likes it, she's a part of the classroom, she's a part of the group, she helps, kids like her, she seems to like the kids. I went to the board and I told them, no good. As far as your case is concerned, where you think the child needs a more restrictive setting, we're going to lose. And it's one of the very few cases where the school told me, you're going to go ahead and proceed with this case despite your advice. And we lost the LRE portion of the case. And I had told them this factor is going to come back to bite us. And sure enough, it did. And then this last one really has to do with the other students. Again, at times, we think in special education analysis that the other students don't matter because we're just looking at the student with disabilities. But in the context of LRE, it does. Is one corner of the law where it's important. What is the child's effect on the classroom and on other students' education? And this one tends to boil down to behavior. If as far as the cases are concerned, if you look at the cases, if the child has a lot of behaviors that are disruptive to the classroom, disruptive to the teacher's ability to teach, and having a negative impact on the other kids, it's in essence a sign that the student may need a more restrictive environment. It doesn't mean you don't try to manage and you don't try to intervene with appropriate positive intervention supports and strategies. But at times, even the best of those strategies, it's still a large classroom environment and regular classes, and the average across the United States is going to be that's more than 20 kids. That's a lot of stimulus for some kids, and that's one thing that can't well be changed about it. And then you move to the second question. After you ask all those bunch of questions, you're already tired with legal questions. They ask you a couple, another one. Okay, if you went through those 6 factors and it kind of told you that the child needs a more restrictive setting, well, have you at least placed the child in regular classes to the maximum extent appropriate? And I like this part of the analysis because it exemplifies that LRE is not an all or nothing concept. It's not all regular class or all self-contained. It's not you're either in a regular class or you're homebound, but rather what is envisioned by Daniel RR, and sometimes this is missed, is a potentially gradual movement to more restrictive settings as necessary for FAPE. And the use of a continuum of placements to manage this, and placement starts in the least restrictive placement possible, and you gradually move to more restrictive settings if it's determined that FAPE's not possible, even with, again, trying with feeling. Which leads me to this graphic. Ain't that fancy? Look at this attorney's graphic. Woo! I kid with myself because I am not a tech guy, and this is about as fancy a graphic as this attorney is going to get. But I think, I told you that I think of legal concepts and pictures, and LRE has always seemed a ladder to me in a couple of ways. That at the bottom, you have the least restrictive setting possible, maybe general ed classroom. At the top of the ladder, you have those most restrictive settings that Amy and I talked about, like the homebound setting that she talked about, a residential placement that I talked about. That's the most restrictive setting. And in the middle, there's, all the shifting, gradually more restrictive environments. But the other part of the ladder that I like is you don't jump up to the fourth rung of a ladder. You move up a ladder gradually. And thus we move up the LRE ladder. We move a step at a time. You don't go from A to Z. I remember I had a case in Isleta Independent School District, and the parent of a child who was fully mainstream just with inclusion support suddenly wanted residential placement. And I remember that the hearing officer ruled against residential placement, finding that it represented an A to Z change in placement in the continuum of placements, meaning she thought you don't go from the least restrictive setting to the most restrictive setting in one step. We move up gradually. Okay, so moves to more restrictive settings, LEAs, these require careful IEP team consideration. Moves to more restrictive settings, not in your state, but in other states can trigger litigation. You guys aren't a litigation happy state. And in states where there's significant litigation, the statehood protection is important, meaning if you're moving a child to a more restrictive setting, the parent really doesn't want that setting, they can get a parent attorney to file for a due process, and that freezes that less restrictive setting during the pendency of the litigation. Okay, and that can be important in litigation context. So if you're going to move a child to a more restrictive setting, it's because you have really solid documentation of your efforts to provide an appropriate education in that less restrictive setting with those support services that you've provided with feeling. Okay. And you must be able to show that the change of placement is warranted. And I think using those Daniel RR questions is a good map. It's a good sort of metric to kind of think through those types of issues. Plan and get guidance before considering a more restrictive setting, particularly self-contained settings and particularly behavior settings, because they tend to generate quite a bit of litigation. I say, I want to leave you with a couple of cases. How can I be an attorney and not talk about a case? You got to talk about cases, right? And I want to juxtapose two cases that reach very different conclusions. And this I want to talk about LRE in the preschool environment for preschool students. Okay, and there's Fairlawn Board of Education. This is a Third Circuit case. And you have a preschooler with autism, and the school wanted to place the child in a specialized special setting that was a pre-K classroom developed for students with autism. And within this pre-K classroom, this is a fancy classroom, there's the ability to provide one-on-one ABA type of programs and reverse inclusion. What does reverse inclusion mean? The Muhammad doesn't go to the mountain comes to Muhammad. The non-disabled students come into the self-contained classroom. And the parents instead wanted the child placed in a regular pre-K classroom. But the court said no. The court disagreed with the parents. The court said, the student lacks the skills to benefit from the regular class. Notice what she's doing. She wanders around the class a lot. She exhibits inappropriate behaviors. You would say, but what about the modeling benefit? But the court noted that she neither noticed or interacted with peers, so the modeling benefit was minimized. But in fact, the student needed lots of one-on-one instruction. And in this one-on-one setting, because of the reverse inclusion, she did have opportunities for interaction with non-disabled peers, with typical peers. But the reason that I selected this case, it's because it's a preschool case, but it's one of those cases where the courts have held the following proposition, which I want everybody to understand, and that's that LRE applies with equal force in the early age context, okay? LRE is a requirement for 3-year-olds all the way to 21-year-olds in the general span of age range and eligibility for special education. Because I think some people sometimes think LRE is different in the preschool type of context, and the courts have said it is not. Okay, now I want to contrast with Tuxedo Union case. Tuxedo Union, it sounds like a fancy district, right? I imagine a lot of tuxedo dress kids. I don't think so. The parent challenged a proposal here to place a child with a pervasive developmental disorder. It's an older case because we don't use that language anymore. And they the proposal was for the school to place this student within the autism spectrum in a special ed class, but the evidence was that the student had actually made good progress in a regular pre-K and modeled from typically developing peers and was able to make progress with the assistance of a one-on-one paraprofessional. And the court said, what's your evidence that FAPE isn't feasible in a regular pre-K? And the school had none. So the school said, the court said, you know, school, your proposal is not the LRE, it violates LRE. So I am going to award tuition reimbursement to the parent because they placed the child in an appropriate program. And the OSEP letters are real clear on making that point that I want to stress, and that is that LRE isn't different for preschool populations. The LRE requirement applies to preschool students. In fact, if you look at the modern language of 300.116, which is a regulation that we talked about, it says that. It mentions preschool students in case we missed it. And there's an older letter from 96 letter to Neveldine that makes that point. The Dear Colleague letter from 2012, in fact, rescinded and superseded by a 2017 letter that makes very much a similar point. And that is LRE applies to preschool students. It applies if they're eligible only for speech services. The child only gets speech services. So where's their LRE? Somewhere. They have to have some opportunity to get an education with non-disabled students, even if speech is their only eligibility. And even if speech therapy services are the only special ed that they get. And another point that's important, LRE applies to preschool students, even if the district doesn't have a pre-K. Okay. So what does the Department of Education in Washington say? Well, how do we do LRE if we don't have a regular pre-K to mainstream a student into? And OSEP generally says, well, schools, you're going to have to explore partnerships with other schools. You have to explore Head Start agencies. That could be the place and the setting where you provide services to this student and they have exposure to non-disabled student. Or potentially, says OSEP, you may have to pay for private preschool and provide the services within the context of that private preschool. So, you know, in Wyoming's model, which is unique, okay, because it's the CDC-based model rather than a school-based model for providing services to preschool students with disabilities. So how do you accomplish LRE in this context? So I think that Wyoming CDCs, your child development centers, will have to focus on, I think, what they've been doing some of, which is reverse inclusion efforts, which is bringing some non-disabled or typically developing peers into these classrooms that normally would only have special education students. That's a way that you can accomplish an appropriate amount of interaction, socialization, and learning with non-disabled students. Of course, the CDCs could create regular preschool programs that could serve as mainstreaming opportunities. In LEAs and school districts that have preschool programs, so then I think that the job of the CDCs is to then kind of export the special education and specialized services to those pre-K programs that exist at the district level. And we did hear about an overall system-wide complaint where there's some issues to deal with it. So I think that the state is in the process of working through this. I do think that the uniqueness in Wyoming's model for providing services to preschool students with disabilities imposes some unique challenges that the state is going to have to work through, and that I think is still getting worked through. And one of those challenges is, you know, if we don't have a pre-K program at the school district, how do we afford LRE to preschool students with disabilities that have to go for these services to a CDC? And the question has to be answered in some fashion, because these kids are equally entitled to be in the least restrictive environment and to have maximum exposure to non-disabled students as any other student. And with that, I close my remarks.
Jose, thank you so much. It's always a pleasure to listen to your presentations. Amy, it is now your time to give any kind of comments or remarks, reactions to Jose's presentation.
Sure, thank you. Great presentation, Jose. Couple of remarks. I think of LRE as a continuum. And I think that's what the law tells us it is. It's an individualized analysis, which is why we have to land at some point at every moment that we reevaluate LRE on a point along that continuum. I'm not so sure that we can presume maximum progress in segregated settings. The segregated settings I see our clients in Minnesota and Wisconsin don't always have challenging curriculum. They don't always have a rich array of extracurricular and non-academic activities. And so I'm not so sure that that is a fair presumption. I like the focus on legitimate efforts, efforts with feeling. I like that. I like that it's underscored, that these are not mere token efforts, that we really have to make legitimate, good faith efforts to stabilize kids in the least restrictive environment before we even can consider moving them to a more restrictive. I don't know that residential treatment could be considered the most restrictive placement because there are no peers at home, unless siblings count, and I sure hope they don't. They didn't count in my home growing up. The capacity to implement the IEP versus legitimate importation of supplementary aids and services to maintain access to the home campus. Those are competing interests, and I think it's an interesting perspective to look at those as competing interests. I think there's a single standard, and I wanted to emphasize my thoughts on it. I think that if there's a better placement in a more restrictive environment for a child, I think that we have to be cautious about moving the child to the more restrictive placement because we think that it might be better for them there. There's one single standard. Either they're getting a FAPE in the placement they're in, or they're not. And if they are, then I don't think we move them to a more restrictive placement. I think that we keep them where they're at. And so long as a FAPE can be provided in the LRE, then we hit all the buttons, and everyone's a winner. The drain on the teacher's time. I think we've got to consider that special educators contribute to modifying curriculum, and they can alleviate the drain on the regular ed teacher's time. I think we have to consider importing special ed supports to the general ed classroom, like co-teaching, like paras. I think that lack of resources is no defense in this context. And so I think that with the Garrett F decision from the Supreme Court that said that, I think that it will be an interesting case to have the courts look at a cost defense to importing supplementary aids and services and giving it a good try versus a defense that it's an expensive proposition. NEBO, the 10th Circuit case that adopted Daniel RR, did not adopt the cost factors of Daniel RR. Not sure, because I didn't look. It'd be an interesting question, but whether the 10th Circuit later did adopt the cost factors from Daniel RR. In discussing a move to a more restrictive setting and fearing that it might trigger litigation, that's always a consideration, but our first consideration has to be do no harm. What's best for the child? How do we fulfill our obligations to the child? Data, data, and more data. Share that with parents. I think the more data we have about how the child is doing, the more we're going to be able to get alignment around the IEP team table, the better discussion we're going to have about the factors to be considered, and the more likely we are to come to a decision. Again, 504 requires reevaluation before a significant change of placement. I think evaluation is often the best tool to facilitate team discussions and decisions and resolution to disputes. And I want to close with another thought about the opportunity for children without disabilities to reap the benefits of early inclusion. It can help all of us develop positive self-images, friendships and social skills, problem solving, respect for others. If we start all kids early on the road to inclusive communities, we can teach our children to practice acceptance and understanding, and to help all learners understand the expectations and how to navigate the classroom. Thank you.
Amy, thank you. Thank you for your comments and your remarks and reactions to that. I think you're right about, so, you know, there's so many times that that children who are not disabled, they end up learning so much more. And I agree with that. I've seen it in my own family and in my classrooms as well. So at this time, we actually have a little bit of time, a little time more for our Q&A, which is good because we have received several questions, which is great. And I'm just going to start here. So the way we'll do this, I'll just read the question, and then if one or both of you want to answer this, you're welcome to do that. If a school has not provided LRE, what recourse is available to families?
Oh, that's easy. I'll take that one. Okay. One is ask for an IEP team meeting to rediscuss the placement issue with some homework done, with some questions to ask. But then we go into the procedural safeguards, right? And the parent can file a complaint with the State Department of Education. The parent can request mediation. The parent can file a request for a due process hearing. And in states that have some facilitated IEP meeting process, I suppose that's another option, which is to get a facilitated IEP meeting where somebody helps you out. I think those would be the parent recourses. I suppose that another one could be an OCR complaint. OCR, because all special ed students are residually Section 504. It's just that their rights are basically subsumed within the IDEA process. You can't file a complaint to OCR on a special education student. They will look at it under the lens of Section 504, but as Amy indicated, Section 504 also has a least restrictive environment formulation. It doesn't have that acronym or that phraseology, but it has that meaning.
I would concur with Jose. The one thing I would add is when I advise clients, families on what to do in any dispute, and LRE is no different, going to the IEP team is a great idea, but going to the IEP team and bringing your district special education director in is even better, because as I tell families, they're in charge of special education in your district. They are the people who are most invested in having relationships with parents, and they are your district's problem solvers. So take advantage of them and then don't lose their number.
Definitely, thank you. Okay, next question. Why aren't 504s funded in preschool? And I think, Jose, I think you started answering that in the chat box, but just in case people missed it,
Well,
I'll let both of you take a
sure.
stab.
Since it's not an LRE question, I just went ahead and answered it in the chat. It's more of a funding question. And the question is that why are 504 students not funded at the preschool level? Unless there's some state funding mechanism, 504 students aren't funded at the preschool level. They're not funded at the high school level. They're not funded at the college level. They're not funded, period. Why? It's the nature of Section 504. Section 504 is a prohibition civil rights law. And by what I mean by prohibition is it prohibits conduct. It prohibits discrimination on the basis of disability. You don't get money at the end of the year because you didn't get a DWI, okay? You're just not supposed to drive while intoxicated. And if you do, then there's penalties. That's the way 504 works. You're not supposed to discriminate against students with disabilities. And if you do, you can suffer an OCR complaint or a federal court action. So that's why 504 does not contain federal funding. And I predict will never.
And I would say, federal 504 services, in my view, are also funded at every level. in that federal funding is contingent on compliance. States don't get any federal funding if they don't comply with 504. Every year, states have to sign assurances of compliance, and that's the key to the federal funding safe.
True. I used to say this, but I've been in OCR complaints already. In the old days, I never dealt with an OCR complaint where the investigator did not mention that the Department of Education could withdraw a district's federal fund. And I always like to follow it by telling, do you know how many times your agency has done that? And after a while, they could not stand the curiosity and they would ask me, do you? And I tell them, yes, I do, 7 times and 3 times to one district. So really, it's only happened in 4 districts total, and requires, by the way, an act of Congress. Not an act, but it requires congressional approval. So it hasn't happened a lot. It's sort of like the thermonuclear bombs, hopefully, but more useful in their threat than in their actual deployment.
Thank you, guys. Okay, next question is, does a child need to fail in a regular education environment prior to providing services in a more restrictive environment when all supplementary aids and supportive services and modifications have been explored to the best extent possible in the regular education classroom? It's a long one. So
I know. I love this question because I don't have to answer it. The Department of Education already has. There is a letter to Hall from OSEP 1997 in which they said there's no firm requirement that a student must fail before there can be a move to a more restrictive setting, as long as the concepts and the requirements that we've talked about and that we've emphasized here are complied with, that you've exhausted the supplementary aids and services that are possible within the regular classroom, and you've provided them with feeling. Yeah, I want to underscore that because it's not supposed to be token efforts. But there's no requirement that the student must demonstrate failure. That'd be kind of perverse. Fail for me, meet my failure standard in order to access the correct services.
But I'm not sure that the question didn't embed within it sincere efforts to bring supplementary aids and services in. And if they aren't working, then that's failure. And so then the question is, how long do you keep good data on the effects of the supplementary aids and services to make a truly informed decision versus dragging out what might be an inevitable conclusion that more supports that can't be imported into the regular ed environment, only available in a more restrictive environment, is what this child needs.
thank you. And I think that just answered, there was another follow-up question to that. Just, does failure instantly mean that LRA needs to be changed? And so I think you just answered that too. So thank you. And then next question is, what about parents who want to put their child in daycare with no preschool curriculum in place?
Well, now that is an interesting question. I'm assuming that the question is in the following context, and that is that there has been an offer of FAPE in a CDC program that complies with LRE, either through reverse inclusion or in some other way. And if that has been offered and the parents decline it and decide for a regular daycare program that is non-educational, to me, I don't see a violation of law. A parent can decline preschool services as long as the compulsory attendance statute doesn't require attendance, for example, of a 3-year-old. If they want to decline the offer of FAPE and take their child to a daycare program, I that's the parents' wishes. That's kind of the what goes along with choice. I think it's a more complicated question when the parents feel that the program at, let's say, at a preschool level at a CDC isn't appropriate and isn't conferring a FAPE, and they think the child's time would better be spent in a daycare environment. That's a little different. Or where they're asking, we want the child to be in a daycare environment for maximum exposure to non-disabled students, and we want you, CDC, to bring the services within the context of this daycare program. Now that's different. That there, the parents could be absolutely correct and could be entitled to that.
Or it could be a case where the parents have declined an offer to provide services in a preschool program and elected to place the child in the daycare program where they were seeking reimbursement for the cost of that placement. But in that instance, the parent would have to bear the burden to prove that that private placement was appropriate. And without services, that would be a tough thing to do.
It's exactly what I thought, right? I mean, the daycare, if we go to the daycare and say, hey, what's your curriculum? None. We keep the students occupied. Well, it's kind of hard to show that it meets any faith-based standard.
No, thank you. I know that there's a lot of it depends in those kind of questions, right? Okay, so I have a question. If a student is receiving their general instruction in the regular education environment, and they are also attending a class for additional support, does that affect their LRE time?
So
Go ahead, Amy.
So if the additional support time is within the school day, and it is outside of the general education classroom, then yes, it has a bearing on the assessment of LRE because it would involve removal of the child from the regular ed environment.
Yeah, and the opposing situation would be if it's not a special ed program, if it's a regular assistance program that's available to all students, and let's say it happens after school, then I actually see it a little different. I see that the student with disabilities has an equal right to access that program under 504. And then I don't think it touches on LRE. That's like a kid that just wants to do tutoring. Okay. Tutoring's available after school. I want to do it. There's other regular ed kids there. What impact does it have on LRE? Zero.
Great, thank you. This is a question that talks about if they're seeing a child, so obviously this must be either a special education teacher or a service provider. They're seeing a child in a community setting and the daycare workers do not and will not modify or follow through with the modifications or the supplementary aids. What do they do in that case? And I'm going to just add to this, even on a district level, if the special education our IEP team has determined certain modifications or supplementary aids, and it's not being followed through in that general education setting.
So whoever supervises the people on the front line who are being depended upon to implement the supplementary aids and services is I think the entity to approach to help to ensure compliance, because it's everybody's responsibility who's on the front lines serving these students to implement the supplementary aids and services that their IEP team or 504 team has decided are required in order to maintain placement in the LRE.
I'm not sure about that. I think a daycare person could be, I don't have any requirement to implement something that somebody else is telling me to do. You're not my boss. The LEA is not my boss. The CDC is not my boss. The parents aren't my boss. I don't see how you can force daycare workers to follow through on services that are part of a student's IEP. Like think about an assistive technology device. Let's say that you have a communication board and assistive technology device. You can suggest that the daycare providers use it, but you can't force them. You could go to their bosses and say, hey, you said you'd cooperate with this. And I think that's about as far as you'd get. Ultimately, if despite approaching it through their supervisor or through the parents, who are actually the ones who are the consumers of the private daycare program, if you can't get it to happen, if you can't get them to use the communication board through that fashion, then I think you're going to have to be at a duty of sending in staff persons that will use it within the daycare environment at appropriate times. But remember, I mean, when we're talking about non-LEA employees, you're asking real nice, hat in hand, will you help us with this? They're not part of the IEP team. They're not responsible for FAPE.
I guess I think it depends on the arrangement, because there are daycares that could be associated with public entities like schools. There could be daycares that are the place in which the child's preschool program is being implemented, and they are then to some extent co-opted into the IEP team process. There could be daycares where the LEA is paying for the child's placement there. So I think it depends on the circumstances.
That sure is different. If the LEA is paying for that, then it has the power of the purse, because it could tell that daycare program, if you don't help us with this and you don't do the communication board, we're going to take the child out. But that's about all you could do at that point. But yeah, I think it would require pre-arrangement, pre-agreement, and the daycare providers may say, look, the reason that we're not implementing these is we need more training on exactly when and how this happens. And I think that could be feasible. That could be done. That could be worked out.
Okay, let's see. We have several, so I'm trying to go through here and see if there were some similarities here that I can combine. One question we have, and I've seen this one quite a bit. What do you do when parents do not support the team, the IEP team, that by the recommendation by the educational professionals for the child to receive support in a lower level LRE?
Yeah, I want to touch on that because that's been an interest of mine. There's lots of LRE cases, but I've got to tell you, there's lots of MRE cases, and MRE cases are where the parent is actually wanting a more restrictive environment, sometimes contrary to even what private experts feel is necessary. You know, Amy and I, and hopefully the folks here are all in unison and in consensus about the benefits of least restrictive environment and mainstreaming in a regular education setting. But I don't think we can aspire that that's universal among parents. For some parents, the most concentrated program that's in the setting that's going to promote the fastest progress possible is the setting that they want. And thus we have some cases where the parents are asking for more restrictive settings than is recommended by the IEP team. And I did an interesting presentation at LRP, and what I wanted to compare is the effect and the strength of the LRE requirement when it's imposed against schools, when schools want a more restrictive setting, and whether it's different when it's the parents that want a more restrictive setting. And generally, I found that when the parents want a more restrictive setting, it seems like the LRE requirement doesn't apply with the same amount of force, that it's sort of seen as a right that's partially waivable. And I'd like to raise that question for Amy. Is LRE a right of the child, or is it a fundamental requirement of IDEA which cannot be waived, or is it a waivable right?
Well, you're not going to use this against me, right, Jose? I think that it is an unwaivable right of the child. And I think that when IEP teams accede to parent suggestions that are contrary to educational professionals, they do a disservice to themselves and ultimately to the child, to whom they have independent obligations to provide a FAPE in the LRE. And my answers would also include what I touched on before. Data and more data is the best tool to get to consensus reevaluation if you don't have enough data, so that people can be on the same page about what a particular child needs, is always a good dispute resolution tool.
I agree. I see it as a fundamental right of the child that is unwaivable.
So I have just a quick note here asking if that case does, even if you've presented all of this and the parent still says, no, I want my child here, are they are they protecting themselves to just make sure that they document that in a PWN? Are they covered legally?
I'm not sure. I think I'm with Amy. This is difficult. I think that what the law wants is for the IEP team to place the child in the setting that's the least restrictive environment. And then the parent has the right to access their remedies, the remedial process. I think that's the way that the law wants it. The law, because otherwise we are treating it as a waivable right. Then we're saying, okay, mom, if you don't want LRE, then I guess LRE, here doesn't apply. But I realize that that's tough because we're basically saying the law then requires conflict and requires the potential for dispute. But I think that is part and parcel of this house.
I think the law does require conflict. I think that none of us should be surprised when it arises, because I think this law was built to expect conflict. It paired parents and teachers and administrators in a joint decision-making role, which is sometimes difficult to achieve. And so I think that that educators can't give up their positions and their obligations to the child to weigh in on decisions that come from their experience. It's in my view why most of the IEP team is made up of educators, because parents rely on the expertise educators bring to the table. And so you have to bring it to the table, and you have to express it, and you have to serve the child, and you have to take a position that you feel good about professionally, ethically, morally.
And it can be tough. I just read a case where the parents disagreed with the part of the child's placement in the special education classroom, and what they would do is pick them up after lunch, because that's when the special ed classes would happen, and essentially they were boycotting them. They were like, we're just not going to send them for that part of the class. So
in that situation, get an independent educational evaluation. Get somebody outside of the district to come in and to do an evaluation of the situation, and hopefully that person can be dependent, can be relied upon. It can engender trust from both sides and can lead to a resolution where there is an independent source of data and recommendation for what ought to occur that can bring the team to consensus.
Well, this next question, I want to be respectful of your time, and so it looks like we only have a minute to go. I'm not sure if you want me to pose this question or
sure, let's do one more.
Okay. So what do you do when a school will not provide any pull-out resource services and want all students to be in full inclusion, meaning no resource room at all? How do you meet LRE, especially when their present levels show the need for sensory breaks, pull-out teaching, or pre-teaching for that student to access full curriculum?
I dealt with this in a South Texas school where the superintendent decided that she just didn't want any more special ed classes at the resource level. So everything was moved just to inclusion teaching. And it was done unilaterally, by the way. The IEPs for students at the end of the year that said they had certain resource instruction at the beginning of the year were just summarily changed to take out the resource instruction and now contain inclusion. And it didn't work, because what happened was the experience showed that actually some students really didn't need the resource environment and really could do well in the regular class with inclusion services, but others could not. The spread between their functional level and the level that the classroom was working on was just too much, so that the instruction that was going on in the regular classroom was just not appropriate. And you know what happened? I visited that school and I saw some kids huddled around a cafeteria table. And you know who those kids were? Those were special ed kids from a regular ed class. And the resource teacher the inclusion teacher had decided to pull them out of the regular class so that she could do some more specialized and properly differentiated instruction in a cafeteria table. So you know what was happening? The teacher created her own resource class, but it was out of desperation. I just don't think, that you're curtailing one aspect of the continuum of placements, and you're just going to find students that really might need that part of the continuum.
And I think you've got to document and collect data on how children are faring in that system, so that when it comes time to making the right decisions, and trouble is coming in that kind of situation, you'll have the right data to make good decisions.
I think inclusion services in the context of a regular class are really, really good services. They ensure that you are more wedded in terms of the child services and curriculum to the regular curriculum, but it's not going to meet the needs of every single student. Some students need smaller numbers, need more specialized instruction that's a little closer to their functional level. But we just can't ignore that type of need exists.
I can't help but think that general ed teachers in that environment are going to be mighty unhappy and mighty overwhelmed, and they might want to talk to their union representatives.
Well, in just in lieu of time, we could keep going forever, but I want to definitely be respectful of your time, and I know it's much later there than here. So, Jose and Amy, thank you so much. We have been richly fed. The chat box is blowing up, just thanking you both so much for the clarification. I know that there's many more questions, and there were some that we didn't get to, but we always have time to take those questions and we can pose those later. We do have an in-person WAVE conference planned in July, from July 26th to the 28th. And, seeing some of these questions and some of the things, looks like we might be revisiting some of this during that time. So please join us in Riverton, Wyoming in July, and watch for the save the date for that. And I just want to thank you again so much. I will definitely be diving a little deeper into these documents that you've both sent and into your slides. And so again, just thank you so much. I hope you have a wonderful spring, and I think you probably get spring there. I'm sure we don't always we have snow on the ground right now.
So do we.
Yeah. So anyway, I just want to say thank you so very much. This has been definitely well worth these 2 hours.
Thank you. It's been a pleasure. Thank you, everyone.
Thank you.
Likewise.
Thank
Thanks,
you so
Amy.
much. And
Bye-bye,
thank you,
everybody.
Tina.
Thanks, Jose. Bye.